Hi, how are you today? So, today I wanted most of today's topic to be kind of a follow-up of last stream I did, which the last stream I did was on the Randazzo family. And then I also kind of didn't get my hair done in time, so I decided that this live stream will also be about my hair as well. So, we're going to begin. I'm going to basically do my intro, and then I'm going to talk about my hair situation, how I styled my hair yesterday, and how I'm going to be doing it today. And we'll be taking down my hair as I talk about it today. And today I couldn't decide if I wanted to put a cream, an oil, or a liquid in my hair, so I decided to go with this scalp hair milk oil bullshit by Chris and S. I don't know, because it's kind of texture wise kind of like a combination of all three in my opinion ish kind of, and so I feel like that would be, there we go. If I can't decide what to put in, that's a good compromise. So I'm gonna be putting that in my hair as I take down my roller set and everything. So in my hair today I have a satin flexi rod, satin lined flexi rod roller set. They're about 3/4 of an inches in diameter if I'm not mistaken. And fucking I'm gonna be taking that down. But yeah, I'm not processing. I'm still drinking my coffee. Well, I'm about to finish it, but whatever. I don't really have an excuse. Life is hard. So I'm going to show you guys how I rolled up my hair yesterday for a job interview with soft foam rollers and what the finished product was with that. Then I'll show you how I rolled up my flexi rods, and I'll be talking about all of that as I take down my hair currently. And then after we finish my hair talk, we will move on to focusing back on the Randazzo family. Yesterday I was kind of going through some legal documentation just out of curiosity, looking at how the Office of Disciplinary Counsel and the Louisiana Supreme Court had handled other similar cases and just other recent cases in general to kind of get a feel for what could potentially be the outcome of my case. Well, in that situation, I saw where Mr. Salvador Randazzo had gotten suspended by the bar, and that case, so I began reading it out of curiosity just because that's a pretty big family in Louisiana. And the case itself, it was a bit rambunctious in my opinion, and so I ended up covering just a suspension aspect of the case in my last live stream about it, and I also covered a bit of the Randazzo family tree history as it relates to the king cake business in Louisiana. And so yeah, that's all in part one. And so today with part two, we're going to kind of follow up on that. We'll be touching back on the family trees again just to have reference for who are the people that are being discussed in the legal documents. And I also did pull up the obituary for Mr. Manuel Randazzo. May he rest in peace. And it's just because of the people in the obituary do kind of, the obituary does give context as to who's in the legal documentation that we will be reviewing. And yeah, with my dad's side, honoring our ancestors is very important to me, and I don't know that dude, so I also feel that just because someone died doesn't change who the hell they were either, right? So I don't know if that man was a good person or a bad person or who he was really, other than the fact that he was part of the king cake family, and they make really good king cakes. They make good king cakes. So, thanks for the king cakes, Mr. Randazzo. Yeah, fucking, I don't know what's wrong with me, but anyway, so I mean no disrespect though by, mentioning these people, and the main reason also is I also do believe that this death is what led to kind of the dissolution of some family unity as it relates to, well, maybe the underlying issues were already there, but he was likely the glue that held it all together, in my opinion, because I believe after his passing is when we see more of this legal action and these family disputes become public, and I think that does provide some context. So we'll be looking at that. We'll be looking at a publication from the Louisiana Ethics Board, or whatever it's called, on Mr. Randazzo's behavior, and we'll be looking at the initial lawsuit, which is how Mr. Randazzo ended up getting suspended as it relates to his family drama. You know what I'm saying? So, yeah, I don't know if I'm using the right words because I feel like I haven't fully processed to articulate it better. And, you know, between that, my slow processing, and between the fact that I'm just not an attorney, so I'm not experienced or have the expertise or the skill set in this field to properly speak on it, between all of that, I don't feel like I'm giving you a good recap, but I hope that it does help for anyone who's similar to processing on my level with this, you know. But yeah, all right, so I'm gonna roll my intro, and then I feel like we're gonna be here for a minute, so I'm gonna roll my intro, and then we're gonna get going, and we'll probably be taking breaks, we'll be chilling, it's just gonna be whatever it is today. So yeah. Hi, my name is Alexis, also known as Flexi or Deaf Child. I was born deaf, hard of hearing. I began doing business as Deaf Child 2013, marketing 2011, sales 2009. I've earned 50 plus certifications in marketing and sales. My Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Deafness runs in my family genetically. Speech is not fully accessible to me. Anyway, I'm here to bitch about whatever the fuck is on my mind. So here we go. Visit my site at noladeafchild.com. So first of all, we're going to start off talking about my recent hairstyling that I've been doing. And so most recently what I had done was soft foam rollers. And that was yesterday morning. And I had a meeting yesterday that I wanted to look good for, but I only had a couple of hours before my meeting when I started styling my hair. I should hit play on this. Yeah, so I only left the rollers in for a couple of hours. I ended up using like an inch and an inch and a quarter, for the different size roller sets, if I'm not mistaken. Oh, you know what? I also think I used the 3/4 of an inch as well. So, I forgot that I used different size there. Let me update this thing real quick. Okay, so I'm pretty sure, if I'm not mistaken, I used 3 sets up in here, right? Yeah, so I used 3 different sizes, and I'm not that good, you know, in terms of like, I feel like if I pre-part my hair, then I can get more of an even situation happening. But part of the way that I attempted to do it, where you see how I have 2 roller sets on top, right? And then the one beneath falls where the 2 lines of those 2 roller sets come together, kind of like a brick. So it's one layer, one, and then one underneath, right? And that's kind of what you can do to avoid having parts showing. So I have so that way every time the top layers will fall over the lines that would have been left from the layers below it, if that makes sense. So that way you are covering any pre-party. And if I attempt to try and do that, sometimes I don't try and do that at all. And so you can see a bunch of parts in my head after I take my roller set out. But if I can, it doesn't even have to be organized, but if you can think to try and do that, it will reduce or eliminate the parts in your hair, so you don't have to mess with your hair as much. But yeah, so I let that sit in my hair for just a couple of hours yesterday because I didn't have that much time. And then on the takedown, this was kind of what it was looking like initially. And then I did add some products to my hair, you know. I was using Tresemme in my hair for the hair oil, like this finishing oil. Some of my Satin flexi rods are about to pop right out. But anyway, so this was how my hair was looking initially. My hair was so fine that I'm surprised that, yeah, there it is, this one's fallen. Okay, so this was how my hair was looking after the soft foam roller set initially. It didn't last very long because I didn't have it set for very long, but it did give me a good little curl and some volume for the next few hours. It fell out within a few hours, but I still had a good amount of volume for the rest of the day. So these few pictures right here, I believe are all from the soft foam roller set, and that is all from this is how it looked immediately after. So far is what we are seeing. This is how my hair was looking immediately after, and then this right here is how my hair looked at the end of the day. So I had taken down my soft foam roller set in the early afternoon, and this is how it looked by evening. So I had taken a shower before I started this live stream, and somehow this one strand of my hair right here is still wet. So what I think I'm going to do is just try and sit here for as long as possible and let this dry as much as possible before I finish taking it out. Even though it's basically out, there's still a little bit wrapped in there, so that way maybe some of that will still kind of curl up a little bit for me. But I feel like this one is basically not going to curl, but the rest of these have hope. I'm gonna let this air dry a little. Oh nope, that just fell out on its own. Okay, well that didn't work. I'm just gonna not touch it for a second. So yeah, so this was the soft foam roller set. So then after that, I decided that I was going to brush my hair out, and then I decided to do the satin line flexi rods that you see right now in my head. Oh, whoops, this didn't start. Okay, so first I had brushed, my hair out, and then I decided to roll these bitches in. They were about 3/4 of an inch in diameter, if I'm not mistaken. And so that's currently what's in my hair. I feel like they're foam on the inside and satin lined on the outside. And I just felt another one drop on the back of my head. So yeah, right there. But that didn't come down as much as this one. So we're gonna let it chill for just a second before we finish taking it down. But yeah. So this is what's been in my head overnight. I'm hoping, because I did let it sit in my hair despite the fact that it ended up getting wet while I was in the shower. I did let this sit in my hair, basically all night for like 12 fucking hours. So I'm hoping that helps, the situation with like preserving what curls are dry. But then when I got in the shower and I took a shower, my hair did get wet, so that was a mistake. I did put a fucking shower cap on, but somehow it's still wet. So right now I'm just going to try and let it air dry as much as possible before I touch it at all and take the rest down. So excuse me how I look, whatever. So anyway, from now on we're going to move up into the Randazzo family tree situation. And then I'm going to take down my hair eventually. Fuck. And so this is just more of like a refresher on who are the characters in this situation, if that makes sense. Who are we talking about here? And so originally Mr. Salvador Randazzo, he was known as Sam. He was kind of like the original grandfather, if you will, of the family business tree for the king cakes. I believe all the original recipes come from him. He opened Randazzo's Highland Bakery. I'm not going to go into all of that history because we did that in the last live stream. But also, I'm curious as to why he went by Sam, because you would think he would go by Sal if his name was Salvador, but he was known as Sam. So he is who I believe is the grandfather of Mr. Salvador Randazzo, who we have been covering because he was suspended by the Louisiana State Bar as an attorney. And for more information on that, check out my last live stream. But also, we will get to that in a minute, so you will see a little bit of what he did. And so, yeah. So his father, I believe, is Mr. Lawrence Randazzo. I believe his uncle, Mr. Manny Randazzo, his passing, because his father, Lawrence Randazzo, and Anthony Randazzo passed before Manny Randazzo. And I believe his passing is when a lot of the issues and the infighting with who should be having what with the corporation kind of came out with these legal lawsuits, So if there weren't any disputes prior to this, it just wasn't made public in my opinion, or I just haven't found out about it. But I believe, from his passing is where he was kind of the glue holding all the sides of the family together. And then whenever he passed, it looks like, in my opinion, It's kind of like Mr. Lawrence Randazzo, like Mr. Salvador Randazzo on his side versus the Mr. Manny's descendants on the other side. You know what I'm saying? In a nutshell, it's probably not that simple, but that's kind of like a rough way of looking at it. And in this last live stream, I did link the source in this description of this video as well. We did go over a bit of the history of the family business in the last live stream, and that information is linked here too. But yeah, and so in Mr. Manuel Randazzo Sr.'s obituary, we can see where he does discuss these people. So I just want to point out the line, so Mr. Manuel Randazzo Sr. was the father of Patricia, who is part of the family king cake business, and Manuel Randazzo Jr., who is part of the king cake business as well, and so is Susan. So they all three of them have their own king cake branches, right? Mr. Salvador Randazzo, the king cake, the bakery that he had opened with his father, Mr. Lawrence, that was destroyed in Katrina, right? But then his sister, they do still have their own Nana Randazzo's king cake situation happening. I believe that's still good to go today, if I'm not mistaken. But yeah, so he could possibly, still be involved with his sister's business, Mr. Salvador. But anyway, back to the other side of that tree, the Manuel Randazzo side here. So Mr. Manuel Randazzo, because these are the people named in the lawsuit, right? So he mentions that he was the brother of Lina Torres and the late Camille Ruiz, the late Anthony Randazzo, and the late Lawrence Randazzo. So Lina Torres and Camille Ruiz are sisters of Lawrence, Anthony, and Manuel, if I'm not mistaken. And so that would make those people Mr. Salvador Randazzo's aunts, if I'm not mistaken, right? And so it also discusses he was the godfather of Petrina Imbraguglio. And we'll also see her come into play as well when it comes into the legal dispute over the family businesses. And I believe it ties into inheritance of these properties and of this family assets, which originally all came from the original Salvador Sam Randazzo. You know what I'm saying? Is it all connecting here now? And so, yeah, just putting the pieces together here of who are we talking about. And so, yeah. To be honest, though, that dude kind of does remind me of, like, the character of Mr. Robert De Niro. Like, just a picture of him. Like, are you talking to me? I'm sorry. Okay, I mean no disrespect. But yeah, so, okay, so before we get to the documents that are further about who that family is and kind of, before we get into those documents though, why we came here was because of Mr. Salvador Randazzo's suspension. And so this little blurb, or a little article, if you will, I don't know, from the Louisiana Legal Ethics website, whatever the fuck. I don't know if it's like a board, committee, whatever the fuck you are, organization. So they had a little article here, and it says, fiery language in court filings can burn your case. And this was posted December 12th, 2024, about a year ago, by Claire Rubian. And it says, in Rendazzo versus Imbraguglio, and some other legal citing shit I'm not good at, fuck that. It says, Justice Christian, sorry, I don't think I said that right, my bad, issued a pointed concurrence addressing the use of discourteous language in a writ application filed with the Louisiana Supreme Court. While the court declined to consider the writ on timeliness grounds, Justice Christian took issue with the applicant's blatant violation of Louisiana Supreme Court Rule 7, Section 7, something like that. Look, I don't know. I'm not a fucking attorney. Look, some shit, which mandates that language in filings must be courteous and free from insulting criticism. Justice Christian, I don't think I'm saying that right, highlighted specific phrases in the writ, such as the trial court's ruling being described as a massacre of justice and the appellate court's decision as feckless, perverse, and aberrant. Am I saying that right? I don't know. He emphasized that such language breaches not only Rule 7, Section 7, I don't know if that's right or not, but also the oath all attorneys take and their profession's broader ethical and professionalism standards. This concurrence serves as a stark reminder that zealous advocacy must always be tempered with civility and respect for the judiciary. Lawyers are duty-bound to uphold professionalism, ensuring their written and oral advocacy reflects the dignity of the legal profession. So yeah. So now let's get into it. So I was trying to find, there's two situations, right? There was an initial court proceeding that was filed in 2021, and then there was some appeal filings, whatever the fuck correct legal terms, I don't know, man, sorry, filed in 2022. And between these 2021 and 2022 filings, all of these two filings are where everything that came out where Mr. Salvador Randazzo was suspended from the bar from, that's where all of these actions and behavior came from, these two cases. So that's what we're going over today. I was looking for more information about the 2021 case online, but I couldn't find it. So I'm going to show you what I could find, and then we're going to go over all of the legal documentation from 2022. If it is online, I perhaps could try and do a better job of looking for it. So I will in the future, and if I do find it, maybe I'll cover it. If it has anything that I feel like is different from the appeal situation, I'm just gonna probably not worry about it though, because in most situations, in almost every single legal case that I've covered, every time there's like an appeal or an update, like to an amended complaint, for example, or something like that, it's all usually mostly basically the same shit as the original thing, with maybe some slight changes usually. And so I'm assuming, keyword assuming, that what's in the 2022 documentation that I actually have available is mostly going to be what is relevant to and pertaining to the 2021 filing. And that will basically be getting the same information either way. So yeah. So first of all, we're going to look at a find law, case law, whatever the fuck, summary on the case from Randazzo versus Imbraguglio 2021. And this is from the Supreme Court of Louisiana. Can I zoom in here? Let's see. That's better. So this is from the Supreme Court of Louisiana. Salvador J. Randazzo, individually, and as executor of the succession of Lorene J. Randazzo and succession of Josephine L. Randazzo and Lorene A. Randazzo versus Petrina Ruiz Imbraguglio, Alex Ruiz, Gerald J. Ruiz, Christy Ruiz Orso, the heirs of Camille Ruiz, Manuel J. Randazzo Sr., Lena Torres, and Rendazzo Property Corporation. So, if I'm not mistaken, who are these people? If I'm not mistaken, I believe Lawrence is Mr. Salvador's father. To be honest, no fucking clue who Josephine and Lorene are, but they're definitely related if I'm not mistaken. Petrina is Mr. Manuel Randazzo Sr.'s goddaughter, if I'm not mistaken. And I believe Camille Ruiz and Lena Torres are sisters to Manuel, Lawrence, and Anthony Randazzo. Lawrence Randazzo, and these are also, Camille Ruiz and Lena Torres are also Salvador J. Randazzo's aunts. if I'm not mistaken. Okay. Alrighty, so just putting that into context. So, then it's got like a docket number 2021 CC 01562, and it was decided December 21st, 2021. And it says writ application not considered. See Louisiana Supreme Court Rule 7, Section 7. And it says, while I agree with the court's decision that this writ shall not be considered, I write separately to note that the applicant's blatant violation of this court's rule prohibiting discourteous language in a writ application is troublesome. Louisiana Supreme Court Rule 7, Section 7, oh, it is section, provides, Section 7, the language used in any brief or document filed in this court must be courteous and free from insulting criticisms of any person, individually or officially, or of any class or association of persons, or of any court of justice or other institution. Any violation of this rule shall subject the author or authors of the brief or document to the humiliation of having the brief or document returned, and to punishment for contempt of the authority of the court. I'm just going to pause here. It feels like they're literally like, yeah, shame, shame, shame. And then, you know what else that reminds me of? Shun the non-believers, Charlie. If you don't know, Charlie and the Unicorn, okay, I'm sorry. I'm going to fucking add that video to the description of this video later, though. So, anyway, I wonder if they're going to steal his kidney. Sorry. Okay. Fucking, where was it? So it says, lawyers in this state take the following oath. I will maintain the respect due to courts of justice and judicial officers. Our professional guidelines similarly require integrity in an attorney's interactions with the court. And then it cites some legal bullshit, like, I don't know, Louisiana Supreme Court ruling Part G, Section 11 or something. We will speak and write civilly and respectfully in all communications with the court. Okay, and then it says, in his writ application to this court, applicant sets forth overly harsh criticisms of the lower courts, describing the corrupt trials court ruling as a massacre of justice and the Court of Appeals' feebly written decision as feckless, perverse, and aberrant. Am I even saying that right? I don't know. In my view, even in the spirit of zealous advocacy, the use of this language violates our oath as lawyers, our professionalism guidelines, and Louisiana Supreme Court Rule 7, Section 7. And then Christian J, or something like that, sorry, I don't think I'm saying that right, additionally concurs and assigns reason. Crane J additionally concurs for reasons assigned by Justice Christian. And then, so then they're basically, yeah, what he said. I don't know. But yeah. Okay, so as I was basically saying, that's why I was saying, like, this is kind of like a little summary, kind of further some recap of how he ended up getting suspended, you know, where some of those actions came from were these cases. And what I found online trying to find more information about the actual case was all related to his behavior as to why he got suspended. I couldn't find the actual document easily online as to, you know, the legal documents from what that case was itself. The closest thing I could find would be the 2022 appeal filings. And so that's what we are actually going to get to read next. And so, yeah. And this is what I think is going to take a second, because this one is like over 20 pages. So, let's see. Okay. So, I was trying to, you know, get this as zoomed in as possible here, but we're working with what we've got. But you know what I could do here is possibly, Yeah, and then we just, ah, ah, okay. So I'm just gonna, sorry, I'm distracted. All right. Ignore me. I'm just moving shit around over here. Okay, so we're actually gonna read this thing now. Apologies. Um, so this is the appeal situation. Again, I couldn't find the original case, but this is the legal inheritance. I believe it was related to inheritance as well as just general family business issues. I haven't actually read all of this, so I'm not for sure. Just kind of from what I can understand from what we know so far. But yeah, I basically believe that this is like a legal dispute over their family business and their family assets and inheritance, if I'm not mistaken, because of the fact that it has to do, it's labeled with execution of succession, which has to do with inheritance typically. But yeah, so it says, so the label of this court filing is Salvador J. Randazzo, individually, and as executor of the succession of Lorene J. Randazzo, and succession of Josephine L. Randazzo, and Lorene A. Randazzo, versus Petrina Ruiz Imbraguglio, et al. And so, yeah, this is from the Court of Appeal, 4th Circuit, State of Louisiana, docket number 2021 CA0679. And so, I've been speculating as to why, a lot of these situations could be perceived as self-destructive. I wonder if part of it does originate from grief within the family on all sides, because I know that grief can really fuck with your head. And if it has to do with a sense of stability, to have your family business, your family empire, and the people who built that and created this for you to pass on, I do feel that could cause a sense of feeling untethered, to the community whenever the people who are why you have community are no longer there to keep you together. It's like as if the Randazzo family, the original Randazzo family king cake, brothers and sisters, but particularly the brothers are more promoted as the king cake makers, when it comes to Anthony, Lawrence, and Mr. Manny, if I'm not mistaken. They're more known for the passing it on than his aunts, if I'm not mistaken. But honestly, I have no idea how, not to discredit, because I know in a lot of situations, women's work is often discredited. So not to discredit their work, but just to say what's publicly promoted, the information available to me. But yeah, so it's like to have those three men pass on. The original Salvador Randazzo has passed on. To have his his legacy, the three that were known for passing on his legacy, to have them all now pass on. Mr. Manny was the last one. And so now what we have are their descendants, the third generation. You know what I'm saying? The third generation is where right now you're at a point where you could fall apart, but there's still a chance to come back together, and I hope they do reconcile and find peace, because I don't believe any patriarch or matriarch builds a family business wanting it to fall apart. I believe, when you put your heart and your soul into building something for your family, it's to support your family, for your family to come together. So I don't know those people, but I don't believe that they would want their family to be fighting this way. You know what I mean? And so I really do hope that they come together, they get back together. And like my twin and I, whenever we go into business together, we always perform better than when we do apart. You know what I mean? Uh, I just feel like, I don't know. I understand also though how family trauma and how social issues and history can get into the way of that productivity though, because sometimes there's too much history to where you can't really be productive because things keep coming up. But I still hope they can find a place of healing. Even if they can't continue in business together because of that history, I hope they can still find healing and reconnect as a family, you know? But anyway, so let's actually read this thing. So it's an appeal from St. Bernard 34th Judicial District Court, number 151017, Division D, Honorable Darren M. Roy, Judge Dale N. Atkins. I cannot speak. So, if I'm not mistaken, I previously thought from the other paperwork that Judge, oh, you know, because this is the appeal. So if I'm not mistaken, Judge Darren Roy presided over the original case, and then when it was appealed, Judge Dale N. Atkins presided over that appeal, if I'm not mistaken. And then it says, court composed of Chief Judge Terry F. Love, that's a cool last name, Judge Dale N. Atkins, Judge Pro Tempore, I don't know if I'm saying that right, Lynn M. Wicker. And then, I don't know if I'm saying that right either. But anyway, then it's got the address for Mr. Salvador J. Randazzo. And it says counsel for plaintiff or appellants. And then it's got the address for Erica N. Beck, as well as Freeman R. Matthews. And it says counsel for defendants appellees. And also it notes that Erica Beck works for law offices of Sidney D. Torres. And so, yeah, and I believe Sidney Torres is a cousin of Salvador Randazzo, if I'm not mistaken. You know what I'm saying? So it's all like a family dispute, if I'm not mistaken. So, I don't know why I expected there to be some sort of, like, title or headline here letting me know what I'm looking at, but the introduction for this, it says appellants Salvador J. Randazzo individually and as executor of the successions of Lawrence J. Randazzo and Josephine L. Randazzo and Lorene A. Randazzo. Hereinafter collectively appellants seek review of the trial court's May 10, 2021 judgment, which denied their motion for injunctive relief and granted the motion to dissolve the temporary restraining order filed by appellees Sidney D. Torres III and Lina Torres Nunez individually and as independent administrator of the succession of Lina Randazzo Torres, hereinafter collectively appellees. For the following reasons, we affirm the trial court's judgment. Okay, so oftentimes when we think of restraining orders, we're thinking of domestic violence type situations or other similar situations where people are putting a restraining order on someone to prevent them from coming near them. But also, if I'm not mistaken, restraining orders can also be used when it comes to things such as family law or estate law. When it comes to accessing certain accounts, for example, you can put a restraining order on somebody who would normally have access to a shared account to not have access to that account for some certain situations or something like that, right? So without knowing anything else about this case yet, I'm assuming that this was a temporary restraining order related something to do with accessing finances, something related to the Rendazzo family business, if I'm not mistaken. But I could be wrong. And the reason I think that though is because, you know, it's in context of execution of successions, which is just a fancy bullshit way of saying distributing assets from the will. You know what I mean? Like, yeah. So, Mr. Salvador Randazzo, he is the appellant. He is trying to appeal the decision. So we know that it went in favor of the Torres family. They were able to, at the end of the day, the law went in their favor with their side of accessing the assets, from my understanding. Okay, so now we're going to get into the factual background and procedural history. And so this starts with the petition for damages. Excuse my hair is dry. It's almost there. So the appellants and appellees are some of the members of the Randazzo family. Members of the family inherited property known as the Highland Double Lot and Highland Avenue property, hereinafter the property. The family members exercised ownership of the property through a family-owned corporation, which is called the Rendazzo Property Corporation, hereinafter corporation. In 2018, the corporation, through its attorney, Sidney D. Torres III, hereinafter Mr. Torres, who is also one of the appellees, filed a petition for damages, hereinafter petition, against several defendants, including the St. Bernard Parish government, hereinafter the parish, and its contractor, Hard Rock Construction Company, LLC, hereinafter Hard Rock Construction. The petition alleged, in pertinent part, that the parish and Hard Rock Construction had illegally encroached on the property. According to Mr. Torres, who has served as the corporation's attorney since its formation in 1982, he drafted the petition according to recommendations from one of the appellants, Salvador J. Randazzo, hereinafter Mr. Randazzo. So in 2018, timeline-wise, Mr. Randazzo is still on good terms with the Torres side of the family. And it wasn't until Mr. Manuel passed in 2019, from my understanding, that timeline is when things began to shift. I believe a lot of this comes from, if you look at the family history and patterns, I believe it could come from not only grief on both sides, but also a sense of stability and where they base their sense of security from is what they are essentially fighting for, in my opinion. Because, sure, superficially you could call it greed, right? If you look at it superficially, it does just look like, oh, rich family being greedy, fighting over how much money they can get, right? But, and then when you look at the fact, of colonialism, where they're over here trying to argue about property for property that's not even fucking theirs rightfully to begin with because they stole it. It's all stolen land. You know what I mean? So we can look at those nuances for sure. But also, it's still, I feel that the reasons that they end up in this situation, though, I don't think it comes from greed. I think because they are all in their own right. They all do have access to enough resources in their own way, from their family business history and from their own legal professions that, well, at this point at least, because maybe for Mr. Salvador Randazzo, now that he has gotten suspended from the bar, maybe that's different. But at this stage, in my opinion, before Mr. Randazzo had jeopardized his career by acting in the way he did, all of the people involved, I believe it all comes from feeling connected to their own family history and their own family business. I think it comes from the sense of stability that was shattered whenever the way that their life has been built, which was through their family business. Whenever the family who built that business passed away, ever since then, their sense of stability is just gone, in my opinion. Because it's that, to me, is what could explain it. Because greed doesn't explain it to me. Because they all had, prior to this, they all had enough resources on their own. So none of them needed shit. And I know that that's not, just because, a lot of greedy people, look at the billionaires of the world, they don't need shit, but they hoard all the resources. So I do understand to a point, just because you have what you need doesn't necessarily mean you're not greedy for more. But to me, it's trying to understand what are the factors that would cause you to have these sorts of disputes with your family, you know? I think there has to be more to it than just greed. I think, you know, maybe I'm wrong, but I just feel like there's something, you know, that's not public that is also related. You know what I mean? Okay, I'm just speculating a lot now. But yeah, okay, so the proposed settlement agreement. I don't know, airplanes are flying over. I don't know if I can hear that. Whatever. Proposed settlement agreement. After filing the petition, Mr. Torres negotiated a proposed settlement agreement, hereinafter proposed settlement agreement, with the parish and Hard Rock Construction. Erica Beck, hereinafter Miss Beck, a member of Mr. Torres' law firm, sent an email on August 17, 2020 to the shareholders of the corporation to notify them of the proposed settlement agreement. In the email, Ms. Beck recommended the proposed settlement agreement and outlined the following terms from it. Okay, so there's a footnote, and then there's also like the way that they have this filed is confusing for me because there's two footnotes and then the letter begins. Well, I can't tell if these items are part of this letter right here or if these items are part of the following or the terms, but whatever. I'm just going to read this footnote and then read what I believe is the terms. So the footnote is number 1. The lawsuit is entitled Rendazzo Property Corporation versus Hard Rock Construction Company, and the docket number. So that's referring to the lawsuit related to the parish and the Hard Rock Construction. And I didn't really look into that because I felt like that didn't, maybe I should, but I didn't know if that explained what could have happened. Maybe I should take a look at that, or whatever. Okay, and then the second footnote says, an email from Mr. Randazzo to Mr. Torres, which is dated July 31st, 2018, included the following. Sydney, here is a draft of the lawsuit against St. Bernard Parish Government, Hard Rock Construction, and its engineers, surveying company, and their insurers. So we know at this point that they're still in good terms. Okay, so now I believe the following items are from the email between Ms. Beck and the recommended proposed settlement agreement. So those terms are 1. Rendazzo Property Corporation transfers ownership of the land directly underneath the encroachment to St. Bernard Parish and grants the parish a 3-foot servitude of access immediately surrounding the encroachments. Number 2, St. Bernard Parish agrees to formally revoke the 3rd Street Road dedication on both sides of Highland Avenue, which resolves any potential title issues related to the corporation's ownership of the property. Number 3, the corporation receives new surveys of the re-subdivided property on both sides of Highland Avenue at no cost to it. Number 4, the corporation receives payment of $24,000. Ms. Beck also noted that the corporation appraised the property at $32,000, while the parish's appraisal of the property was $24,800. After learning that appellants objected to the proposed settlement agreement on September 4th, 2020, Ms. Beck sent out another notice and an agenda, which relayed that the corporation's president, Lina Randazzo Torres, intended to call a special meeting of shareholders on September 25th, 2020. Okay, interesting. You know what? I think my hair is dry now, so I'm going to go ahead and start taking this down. It's dry now. Well, this is still kind of wet, but fuck it, you know. So, the September 25th, 2020 meeting. At the September 25th, 2020 meeting, hereinafter meeting, with the exception of appellant's interests, the shareholders' interests were represented by signed proxies. The signed proxies were made available at the meeting. those represented at the meeting in the value of their shareholder interests, as indicated in the roll call vote, included the following. So present, we had Lena R. Torres for president by proxy through Erica Beck, 40%. Oh, and a footnote here, it says other persons who attended the meeting included Lorene A. Randazzo, Mr. Torres, and attorney Freeman R. Matthews, the court-appointed facilitator, and facilitator's employee. So then it says succession of Manuel J. Randazzo by proxy through Woody Woodruff, 20%. Succession of Lawrence J. Randazzo and Josephine Randazzo through its executor, Salvador J. Randazzo, 20%. Heirs of Camille Ruiz, I don't know if I'm saying that right, Alex Ruiz, 5%, Petrina Imbraguglio, 5%, Gerald Ruiz Jr., 5% by proxy through Erica Beck, and Christy Orso by proxy through Rodney Orso. I don't know if I'm saying that right. Orso, I don't know. 5%. And so yeah, and then it says Miss Beck. So wait, hold on. I think that these are the if I'm not mistaken, the value of their shareholder interests. So this is who was at the meeting, and so we just went over who the list was like at the meeting and their proxies, but I'm just going to recap real quick who are what the shareholder interests are again real quick. So recap of the shareholder interests. Lena R. Torres has 40% and she's the president. For the succession of Manuel J. Randazzo, that's 20%. Succession of Lawrence J. Randazzo and Josephine Randazzo is 20%. The heirs of Camille Ruiz combined make up 20%, but Alex Ruiz gets 5%, Petrina Imbraguglio gets 5%, Gerald Ruiz Jr. 5%, and Christy Orso, something like that, 5%. Okay. And so then it says, Ms. Beck served as the proxy vote for Lena Randazzo Torres, who was the president of the corporation, and acted as representative of a combined 55% of the proxy shareholder interests. Additionally, Ms. Beck chaired the meeting over appellant's objections. Appellants demanded copies of the proxies, documentation of the standing of the proxy shareholders, and the proxy's entitlement to vote. Although noting appellant's objections, Ms. Beck proceeded with the vote. All the represented interests, with the exception of appellants, voted to approve the proposed settlement agreement. So, in my understanding, though, they had the majority of the shareholder interest, which leans into, how much their vote weighs and counts, if I'm not mistaken, depending on, how they do things. But yeah, so if they represented the majority interest, so I think, that right there, that power imbalance could be what the issue is. It could be a situation where perhaps I'm speculating, I don't know shit, this is pure speculation, but it comes off when you look at the combined documentation. For me, it could kind of appear as if Mr. Salvador Randazzo is for some reason frustrated or upset that he's not the president or he's not the one in charge. You know what I'm saying? That's without knowing any other context for this situation, in my opinion, that's how it can come off. Because it's nice to have your voice heard, and that's part of what being on the board is for. But at the end of the day, this is what your interest represents. And so it's not only how much you're going to be earning in the profit sharing, but also it's how much your vote counts typically, in my understanding, in the matters of the situations, But it does make sense where people who have more risk at stake get more of a say in what happens in certain situations, I don't know. I honestly don't have enough, information to say whether or not this is fair in terms of how it was all set up. But at the end of the day, it is the way it was legally set up to be, whether or not you think it's fair. So as an attorney, you have to follow the law. So from that situation, maybe it's just not put into the paperwork, but I just don't understand where he is coming from, you know, I don't know. But anyway, so yeah, it looks like though the key issue here is that Mr. Randazzo, Mr. Salvador Randazzo, he was against the proposed settlement agreement that the rest of the family wanted to have with St. Bernard Parish, if I understand correctly. So yeah, okay, now we're moving on. The motion for temporary restraining order and injunctive relief. After the meeting on October 15, 2020, appellants filed a motion for a temporary restraining order and injunctive relief. Hereinafter, motion for injunctive relief against the heirs of descendant, Camille Ruiz, namely Petrina Ruiz Imbraguglio, Alex Ruiz, and Gerald J. Ruiz Jr., Christy Ruiz Arso, and the heirs of descendant Manuel J. Randazzo Sr., Lina Randazzo Torres, the corporation, and Mr. Torres. Okay, you can't keep the whole family from accessing the family business. That seems quite a little bit ridiculous. I understand if you had a valid reason, you know, perhaps somebody was misusing the funds or something. I'm not saying anyone did, but I'm just saying, like, speculating as to a valid reason to put an injunction on family from their own business. But for wanting to, because most of the family wanted to settle with the state and you didn't want that, trying to stop them from being able to do what they are legally allowed to do based on these contracts, it comes off as a little, you know, like how when you get playing a game and you lose and you're upset, so then you try to flip the whole board game over. Yeah, I don't know. Okay, so anyway, the rest of this, it says they sought to enjoin future shareholder meetings for the failure of the meeting to comply with Louisiana Business Corporation law. And they, well, if it did fail to comply, I don't understand how it did so. And I'm assuming it didn't. Otherwise, I don't know if the court would, because if it didn't comply with law, it would look really bad on the court, right, to be publishing what it's publishing. So part of me is like, you know, maybe they are following the law, but at the same time, I also believe that the United States Supreme Court is currently violating the Hatch Act. So, you know, like, you never know. Just because someone is an authority figure doesn't mean they're doing what they're supposed to do. I understand that for sure. But I am saying, like, it would look really bad on them if it turned out, you know. So, and from what is published, from what I can tell, it doesn't look like any Louisiana Business Corporation law was violated that I know of. But if there was any evidence to back that up, it just hasn't been made public, or if it was made public, I didn't find it yet. Anyway, so sorry. Okay, so I'm going to just keep reading from right here. So they sought to enjoin approval and enforcement of the proposed settlement agreement. Appellants contested, in part, the validity of the proxies cast involving heirs of Manuel J. Randazzo and Camille Ruiz, as well as Mr. Torres' standing to negotiate the proposed settlement agreement. So how is he going to try and contest the validity of the proxies? Okay, I feel like that's a stupid contest. Like, he's trying to say, oh, if you're not in person, or whatever. I do know that there can be situations where, you know, certain people, depending on the agreement, like, if you don't attend a meeting, then your vote just doesn't count. They don't allow proxies, you know. That sometimes that could be a thing. But at the same time, unless that would have to be explicitly in writing. Otherwise, generally, typically speaking, legally, like, proxies are totally normal and allowed, you know. So you would have, like, that doesn't make sense to me. I don't know. You know what I mean? But yeah. So yeah. And then in terms of, like, involving the heirs, aren't they all just as much of a cousin of yours, or your aunts and uncles? Aren't you all just as entitled to the original Salvador Randazzo's legacy, you know, in my opinion. So why would you be fighting over who's more related? You know, I feel like the only time you can really argue with someone about that is if they married in. Speaking of, I can totally see why. I think it was, what was it, Mr. Manny Randazzo Jr.'s ex-wife, if I'm not mistaken. I could be getting that wrong. But I could totally see why when one of them, their ex-wife, she tried to start her own king cake business, and they had to take legal action to make sure she wasn't marketing her king cakes as Randazzo king cake, and then she had to market it as Kaluta king cake, which is her other business partner now. And I do agree with that, though, because you know, like, if you're gonna marry into a family business that is having their own king cake recipes, I don't believe that you should go compete with them on their name, on their family business, when you've had access to all of their family recipes and secrets and shit. You know what I mean? Like, so I do agree with that. Like, yeah. But anyway, I'm sorry, I am rambling. So anyway, the rest of this, it said, in response, the trial court issued a temporary restraining order, which restrained and enjoined the setting of any more meetings of shareholders or directors during the pendency of the proceedings. Additionally, the temporary restraining order restrained and enjoined any action concerning the property, including but not limited to any meetings or agreements with the parish, any representatives of the parish, and Hard Rock Construction. So yeah, I was kind of off, but kind of right at the same time. Like, I thought that the restraining order had something to do with assets, and it kind of did, but it more so had to do with preventing them from moving forward with the business deal without his consent, in my opinion. You know what I'm saying? If I understood that correctly. So, yeah. And then now we're moving on to the motion to dissolve the temporary restraining order. On October 19, 2020, the appellees filed a motion to dissolve the temporary restraining order and an opposition to the motion for injunctive relief, hereinafter a motion to dissolve. Appellees argue that appellants did not demonstrate irreparable harm so as to warrant issuance of a temporary restraining order or a preliminary injunction. Moreover, appellees averred that the corporation secured proper shareholder authority to approve the proposed settlement agreement. The trial court conducted a hearing on appellant's motion for injunctive relief. Did I say belief? I meant to say relief. Whatever. For injunctive relief and appellee's motion to dissolve on May 6, 2021. In the footnote here, it says the motion to dissolve temporary restraining order and opposition to injunctive relief was initially filed by Lina Randazzo Torres and Mr. Torres. However, Lina Randazzo Torres died in 2021. Oh, may she rest in peace. Thereafter, her daughter, Lina Torres Nunez, was substituted as a party as an independent administratrix of the estate. Because Ms. Torres died intestate, Lina Torres Nunez and Mr. Torres, as her children, inherit in equal shares to her interests in the present matter. Aha. Okay. May 6, 2021 hearing. At the hearing, appellees, through their counsel, Mr. Beck, did I say Mr. Beck? Miss Beck, emphasized that Miss Beck sent notice of the proposed settlement agreement to all shareholders, that appellees formally noticed a corporate meeting once appellants objected to the proposed settlement agreement. Apologies, I'm distracted with my hair over here. But you know what? Before this is how the situation came out. Yeah. Anyway, comb it. My bald ass head is showing. Okay, so apologies. I'm just gonna go again. At the hearing, appellees through their counsel, Ms. Beck, emphasized that Ms. Beck sent notice of the proposed settlement agreement to all shareholders and that appellees formally noticed a corporate meeting once appellants objected to the proposed settlement agreement. Appellees explained that most shareholder members submitted proxies because they wanted to avoid a contentious family meeting. Further, appellees stressed that the proxy statements were detailed and specifically outlined how each party intended to vote. They also emphasized that proxies are allowable under Louisiana Business Corporation law. Ms. Beck explained the proxy votes in her role as chair of the meeting as follows. And I'm just going to pause here too. To be an attorney arguing, that something isn't legal when it actually is legal, and then to have that proven in court kind of makes you look like, you know what I mean? Like you're not, you know what I mean? Like it's totally, and I understand there's so many areas of practice that it's not possible for an attorney to know everything about every area of practice. For example, I don't think that the personal injury attorney that I work for knows much about disability law, but, or employment law for that matter, shit. Like at a certain level though, if you don't know about the law and you're making claims about the law and you clearly are wrong, it doesn't look good for you, in my opinion, in that legal filing, if I'm not mistaken. But anyway, okay, so, where Ms. Beck was explaining the proxy votes and her role as chair of the meeting, that's what we are reading now. As the proxy for Miss Lena Randazzo Torres, which is the second Lena Torres, if I'm not mistaken, I did run the meeting as she was the president. We have all the numbers laid out in there, but essentially she is a 40% owner. And Mr. Manuel J. Randazzo Sr.'s wife, who was inheriting everything under his share, was a 20% owner. Her attorney was there with a signed proxy, Mr. Woodruff. We each had 40% and 20%. In addition, the Ruiz heirs, Miss Camille Ruiz's children, had proxies. I had 3 of them. And then Miss Orso's children, Then Miss Orso's husband attended as well with her proxy. They represented another 20%. They did not have a succession open, but they were the heirs? Shit, fuck, man. I feel stupid. I don't know. They were the heirs, and they had, I don't know, man. What the fuck is wrong with me? And they had season. What the fuck does that mean here? But they were the heirs and they had season? I don't know. The fuck does season have to do? Are we seasoning a cast iron skillet? Whatever. Anyway, I don't understand that context. And then it says that would bring it to 80% in favor of this settlement. The settlement is reasonable. The reasonableness of this settlement is, and then it says is not. The reason, that's interesting. It says in brackets, it says is not. That's hypocritical. So, alright, I'm going to read it with and without the brackets. Without the brackets, it says the reasonableness of this settlement, really before this court directly. But we do have documentation in there as to the settlement and why we believe it is reasonable. So, okay, in brackets, they're saying it's not before this court. Alright. Anyway, I don't understand. Life is hard. I guess they mean that's not something the court is looking at right now. But anyway, so then it says other parties were represented by counsel who showed us proxies believing it was reasonable. We proceeded that way. We have got the judgment of possession for Mr. Woodruff's case, showing that his heir had full possession by a court order prior to the meeting. And, even if there was something we did not like about the meeting, we would have been prevented from having another meeting this whole time because of the temporary restraining order that was put in place. So, it is not like there is something we do not like. We want to do it again. We could not do that. The brackets are really throwing me off because I don't know if that's where they're putting words in her mouth or if they're taking out something out she said and replacing it, or you know what I mean? Like if she didn't say those things, but they're filling in the context for her. So yeah, that threw me off. But I was just trying to read to you what the fuck it said, but processing it and reading it was hard for me. Anyway, and then this thing says, appellees added that the terms of the proposed settlement agreement reasonably favored the corporation because the encroachment permitted was relatively small. The shareholders received $24,000, which constitutes nearly the entirety of the parish's $24,800 appraised value of the property, and the terms granted the ability to list the property for sale. So yeah. You know, at the end of the day, though, even if he's unhappy with the decision, as a shareholder, he still gets money. So it's like, why are you bitching? I don't know. Maybe I'm wrong for thinking that. Anyway, so then it says, appellant's counsel, Mr. Randazzo, relayed that appellants wanted to remove the encroachment. He asserted he did not trust the parish and that there is nothing that St. Bernard Parish can say to me that I am going to take at face value. He described the proposed, this is going to go real well for him in court now, isn't it? Anyway, it says he described the proposed settlement agreement as a one-sided deal and that they may as well have left the defense attorneys to write it up. With reference to the meeting and the proxy votes, he argued as follows. But the way that the meeting was called, and I think the way future meetings were called, and I also had spent many time reading Professor Morris's works on the new business corporation law. And she talks about proxies. Proxies are allowed, Judge. As far as I checked with Mr. Nunez's office, there is no succession open for Camille Ruiz. There is no succession open for Petrina Imbraguglio. They just opened the succession for Lena Randazzo Torres or something like that. Your Honor, a proxy has to be based in a legality. You cannot simply go to somebody and say, could you imagine you had 10,000 shares in Exxon, Judge, and you died. They went to your son, and your son tries to go and vote your 10,000 shares of Exxon. They would kick you out the door. They would want to know, did you open Mr. Roy's succession? Do you have letters testamentary? Do you have a judgment of possession? I asked Mr. Arcel all of these questions at the meeting. He said, no, we did not open succession. No, we have no judgment of possession, but I am here with a proxy. I am here with a proxy that Miss Beck sent to him. I'm here with you and I'm joining the 40% shareholders to push this through without any consideration of whether or not it is in the best interest of the corporation. I do not believe it is. And as you read this, Lena Randazzo Torres was a qualified director, and she could not allow her son to handle this settlement because there is a material interest, familial interest, which is barred by the new corporation law. They simply ignored the new corporation law. They simply ignore succession law that says you have to have a succession open and be appointed executor or administrator, then proceed. So from here, perhaps there's something that I'm not processing or I'm unaware of as it relates to the timeline of when these people passed away, when they had to have their succession open, which is like the legal formal proceeding where you transfer assets officially. Otherwise, it may not be legally official. And so I think, that concept right there is what Mr. Salvador Randazzo is trying to argue, to say that those proxies don't count, because if the interest that we're speaking on is for the people who are the executors of these successions, if the succession isn't opened, then the executor cannot authorize someone as a proxy if they're not actually the executor yet, right? But I believe the government is arguing that, or the other side is arguing, not necessarily the government, but what's in the government filings is that the family and the corporation is arguing that, they did the succession and the estates properly, that's a separate issue, that the people who are the actual executors of these estates do legally authorize and assign their own proxies to attend the meeting. I think that's where the debate is. You know what I'm saying? But basically, it looks like Mr. Salvador Randazzo is unhappy with the family decision for the direction of the business and is just trying to stop it at any means possible. I feel like either the way he's arguing though makes him look like he isn't familiar with some of the law that he's speaking on, which doesn't make him look good as a lawyer, or it comes off as if he may know these things, but he's still trying to argue anyway just to make it more difficult. You know what I'm saying? I don't know. I'm speculating. I'm not saying what his intentions were or what he knows. I'm saying that's how it can come off from the paperwork we're reading. You know what I'm saying? Anyway, but yeah. Okay. So then the rest of this document says, Mr. Randazzo further expressed appellant's objection to Ms. Beck's chairing the meeting in the place of Lina Randazzo Torres in the following respects. If you read the new corporation law, she, Ms. Beck, says, just because Lina Randazzo Torres was president and gave her a proxy, she should command the meeting. No, she cannot, Your Honor. Any meeting of shareholders or directors, the chairperson of the meeting has to be elected by those members present, whether they are members of the board of directors or members of the shareholders. She cannot walk in, as she tried to do, and take control of the meeting and say, here I am, I have everybody's proxy, we're going forward, and that is why I filed for a temporary restraining order, Judge. Okay, so basically, the person who would officially be in charge of leading the meeting sent a proxy, and that proxy came in like, hey, I'm here in place of her, let's get this meeting going. And he is saying, well, even if she can send a proxy legally, that doesn't mean that proxy can be in charge of the meeting, is basically what Mr. Salvador Randazzo was trying to argue. But from my understanding, who the fuck is in charge of the meeting doesn't matter, because I don't believe that would have changed which way everybody voted. I believe Mr. Salvador would have to prove that she somehow influenced the meeting to go that way, you know what I mean, in order to somehow then invalidate the legal direction. But even if you don't like the way that meeting was ran, I don't think that should be something that then goes to court, because honestly, the court can't control what the fuck happened in your family corporate meetings, for real though. Like, that has to be something y'all work out on your own, in my understanding, if I understand correctly. You know what I mean? Like, I don't know. But anyway, okay, so I guess this is what he's just trying to argue, so he can basically be like, yeah, I'm very aware of, you know, like the fact that we can use proxies, but it's the way they use the proxy or some shit like that. I don't know. But anyway, so then the documentation says, appellees countered that appellant's real reason for opposing the proposed settlement agreement was revealed in paragraph 23 of the motion for injunctive relief, wherein Mr. Randazzo stated that he would not consider entering into any settlement with St. Bernard Parish Government while St. Bernard Parish Government left unsettled the litigation against the plaintiffs in rule and utter egregious conduct by St. Bernard Parish Government against the Lorene and Joseph Randazzo family. Okay, alrighty, so it looks like here's the crux of the matter that I wasn't understanding. Mr. Salvador is, the original issue may have escalated to end up being a fight with his family, you know. I still do believe the fact that Mr. Manny Randazzo passed in 2019, so therefore he wasn't the glue to hold everything together and to help keep these people in place, you know, if they have any respect at all for their elders. But at the same time, he's disrespecting his aunts, so maybe he doesn't respect his elders. But, you know, like, when you look at all of this, it looks like, I think it could stem from some grief related to the passing of his parents. You know what I'm saying? Right, because he's saying he doesn't want to settle with St. Bernard Parish Government, which is what the family wants to do, which is why he's arguing with the family, because his parents and the St. Bernard government had issues. But, I think that must come from grief, you know? But yeah, I don't know, I'm just speculating. So anyway, it says, in light of same, Appellees requested that the trial court dissolve the temporary restraining order, deny the request for injunctive relief, and reserve appellees' right to seek damages for wrongful issuance of a temporary restraining order. Appellants conceded that they had some issues with the parish and expressed concerns about the parish's relationships with some members of the corporation. Appellants pointed out that a family member's husband works for the parish's fire department and that Mr. Torres' son has a garbage contract with the parish. So, there are a lot of disqualifications as far as their shares that she is talking about being able to vote. Appellants maintain that the effort to approve the proposed settlement agreement contravened Louisiana law, was not in the best interest of the estates of Lawrence Randazzo and Josephine Randazzo, and that they needed to be compensated correctly. So to a point, like, you know, I do agree that as his executor, he can speak on what he believes would be in the best interest of that estate. But at another level, when you look at the percentage of the share, I think his share of interest is like 20%, if I'm not mistaken. So when you look at that, like, the majority rules type situation, you know what I mean? Like, maybe the next time it'll be in your favor, but I think at the end of the day, those are two separate legal issues, and fighting with your family to not settle on this one legal issue because you're so upset about your parents' conflict with another issue won't change that. You can't change that history. It's two separate cases. So for me, I'm having a hard time understanding why you would escalate with your family this way just because of that. And the only conclusion or the only logic I can make of it has to be something tying to grief related to the death of the family, you know? But yeah. So for judgment, it says, at the conclusion of the hearing, the trial court orally ruled that the court is going to grant the motion to dissolve the temporary restraining order and deny the injunctive relief, as well as deny any penalties against Mr. Randazzo, such as attorney's fees and so forth. The trial court rendered written judgment on May 10, 2021, and it provided an pertinent part. It is hereby ordered, adjudged, and decreed that 1. Lina Torres Nunez, individually and as independent administrator for the succession of Lina Randazzo Torres, and Sidney D. Torres III's motion to dissolve the temporary restraining order is granted, and a temporary restraining order issued October 15, 2020, and the above captioned proceeding is hereby dissolved. 2. Salvador Randazzo, individually and as executor for the succession of Lawrence J. Randazzo and succession of Josephine L. Randazzo and Lorene Randazzo's motion for injunctive relief is denied. 3. Lina Torres Nunez, individually and as independent administrator for the succession of Lina Randazzo Torres and Sidney D. Torres III's request for damages, attorney's fees, and costs is denied. This appeal ensued. So, yeah, it looks like Mr. Salvador lost some and won some, and Miss Lina won some and lost some. This looks like a good compromise. Lina was asking for, it looked like Miss Lina was asking that Salvador have to pay for all the legal shit. The court said, no, we're not going to make Salvador pay, but at the same time, y'all still get to do whatever the fuck you want with the company business. Salvador can't stop you. So I feel like that sounds like a fair compromise to me on surface level. But yeah, that's what I think should have happened, in my opinion. Anyway, let's read this footnote. The footnote here, okay, I'm going to read, the footnote starts at the beginning of page 9, but then continues on page 10. So I'm going to read that footnote, and then I'll scroll back up to keep reading the actual page 10. So the footnote here says, on May 18, 2021, appellants filed a notice of intent to seek a writ of the trial court's written May 10, 2021 judgment. appellants obtained an extension of time and timely filed their writ application on June 11, 2021. This court in Randazzo et al. Versus Imbraguglio et al. 2021-0355 and some other legal shit cited, noted that the trial court's judgment denying injunctive relief was an appealable judgment pursuant to some other legal shit here, and as much as appellant's notice of intent was done within 15 days of the judgment. Appellant's writ was granted for the sole purpose of remanding the matter to the trial court to consider the notice of intent as a motion for appeal. On remand, the notice of intent was converted to a motion for appeal. I don't know the fuck the difference between the two, but whatever. Okay, you know what? Let's Google that. So, a motion is a request to the original court to review a decision. An appeal is a request to a higher court to review the original court's decision. Okay. So, basically, a motion is when you go ask your granny if she's going to take you to Wendy's for a Frosty. And whenever she says no, an appeal is when you go ask your grandpa if he'll take you to Wendy's for Frosty. Alright. So, anyway, for assignments of error, on appeal, appellants assert 6 assignments of error. Number 1, whether the shareholders' meeting of September 25th, 2020 was improperly held because there was no election of a meeting chairperson as required by the Louisiana Business Corporation laws, and Erica Beck acted as corporate secretary when the duly elected corporate secretary and only living corporate officer was present to perform the duties of corporate secretary. 2, whether it was legal for Erica Beck to obtain proxies from the children of descendant Camille Randazzo Ruiz, who Erica Beck claimed were Camille Randazzo's legal heirs. Why am I saying hair? I want to say hair, like pronounce the H every time I see that word, but I know in my head you don't say it, but I keep doing it anyway. Yeah, anyway. So, Camille Randazzo's legal heirs, without the production of formal letters, testamentary, or a judgment of legal possession placing said children into possession of descendants' estate, and where Erica Beck did not produce a copy of Camille R. Ruiz's will or a judgment of possession or letters testamentary. But in my opinion, number 2, it's like they all know these people are who the fuck they are and are legally therefore entitled to this shit, but they're trying to act like, oh, well, you didn't bring the paperwork, so therefore we're going to ignore your legal rights. Such bullshit. Like, I do not understand this formal procedural bullshit. I feel like it's a waste of resources. Like, literally, you did all of this just for it to be what it was going to be anyway. Okay, item number 3. Whether it was legal for Erica Beck to obtain proxies from Cheryl Randazzo, the surviving spouse of descendant Manuel J. Randazzo Sr., through her attorney, Walter Woodruff, who had a proxy from Cheryl Randazzo, but without the production of formal letters, testamentary, or a judgment of possession, placing said Cheryl Randazzo into possession of the succession of Manuel J. Randazzo Sr., and where no one produced a copy of Manuel Randazzo Sr.'s will, a judgment of possession, or letters testamentary. Okay, I'm gonna stop right here real quick. So again, like when it comes to situations with corporations and government where it's not family, no family relation, I absolutely believe that these elements do need to be put into place. So I do understand why this procedure is there, because when you're not family, you don't already have these separate legal rights to the assets, you know what I'm saying? And so it is important to have this procedure in place when it comes to the distribution of business assets and the paperwork, because you can't just have someone come claim that they're so-and-so's family and therefore they're entitled to shit and you don't know who the fuck they are. You know what I mean? Like type thing when you build a business, right? But in this case, they all know who the fuck each other are. They all are family. they're all legally, due to Louisiana law, and we already know that they're inheriting shit, all right? What that shit is going to be, the percentages and all of that, what have you, will vary based on the paperwork, how they filed it. But at the end of the day, we do know that they're entitled to this shit. And and if it were how much of an interest they had, up for dispute, like, then I get kind of being like, well, we need this paperwork filed in accordance to that. But if that's not up for dispute, if it's only up for dispute whether or not someone who we know is the legal family and legally and the heir of this shit, whether or not they should be present at the meetings deciding the things that they are legally inheriting, that's just bullshit in my opinion. We're wasting resources. What the fuck are we doing? You know what I mean? But anyway, so number 4, whether after Erica Beck adjourned the shareholder meeting, was it legal and proper for her to accept documents and make them a part of the meeting when those documents were not produced during the shareholder meeting? Number 5, whether the corporation's president and shareholder of record of 20% of the outstanding shares of the corporation and alleged owner of another 20 shares, Lina Randazzo Torres, was properly considered a qualified director pursuant to the amended Business Corporation Law, and therefore was prohibited from having her son act as the attorney to negotiate a settlement of a lawsuit without disclosing any conflicts of interest. Number 6, whether the trial court committed manifest error when it denied appellant's request for preliminary injunction, where appellants established prima facie evidence of defendant's violation of corporation law, and by failing to apply the judicially created exception to some Louisiana Civil Code Procedure Article 3601 bullshit, which allows for the issuance of an injunction without showing irreparable injury when the action sought to be enjoined, is a violation of a prohibitory law. In sum, appellants seek review of the trial court's denial for their motion for injunctive relief. So, so just to sum up what we've been reading so far, because we are on page 12 of 23 right now of this paperwork. So I actually think this is a good time to take a little break. But from what I can understand, basically it looks like there was some sort of dispute between St. Bernard Parish and Mr. Salvador Randazzo's parents. And that dispute, from my understanding, is completely separate from this other issue at hand here, but is Mr. Randazzo's reason for taking action in this case. So, in a separate legal case, the Rendazzo Family Corporation had basically decided to come to a negotiation with St. Bernard Parish as it related to issues related to construction on their land and things of that nature. For whatever reason, Salvador is basically like, I want nothing to do with St. Bernard Parish because they disrespected my parents, basically, from my understanding. And because of that, Mr. Salvador is doing everything he can to prevent the Randazzo family from moving forward with their corporation and their business negotiations with St. Bernard Parish. So he went so far as to try and legally prevent them from being able to do anything with the business by trying to put an injunction, so that basically trying to make it so that they can't do anything without court approval or his approval, right? So the court ruled in favor of the Rendazzo Family Corporation, which was against Salvador Randazzo's interest. And Salvador Randazzo basically kind of in my opinion, potentially lost his shit. So that's kind of where we're at. That's a terrible summary, but I processed delayed, so that's the best I can do for you right now. So what I'm going to do is take a little break. And then after that, we are going to finish out the rest of this appeal documentation. So yeah, and we'll just wrap up from there and continue going from there. Thank you for joining me today. I appreciate you, and I will see you in 2 shakes of a lamb's tail. I'm just going to keep reading and just pick up right where we left off. So, we left off here on page 12 of 23, and this is the appeal case situation when it comes to Salvador Randazzo, basically against, not like all of the rest of his family, but most of them, but like a lot of his family, against basically the other side of his family, you know. Anyway, so it's basically him against his aunts and cousins, if I'm not mistaken. Alright, so we have the standard of review. An appellate court reviews a trial court's decision on the grant or denial of a preliminary injunction under the abuse of discretion standard of review. Raiders versus Deville, citing some shit here, fuck that. And oh yeah, you know, before we go into the standard of review though, sorry, I probably should have summed this up better, but basically though, the situation, it started out, there was a legal dispute between St. Bernard Parish and Mr. Salvador Randazzo's parents, and then after that, the St. Bernard Parish illegally built on the Rendazzo land, and so the Rendazzo Corporation came to an agreement and a settlement with St. Bernard Parish, but Mr. Salvador Randazzo doesn't want to agree to that agreement because of his parents, apparently, and is basically doing everything he can to stop it, or he was trying to back then, at the time of this paperwork that we're reading now. And so this case, also how we got here, Mr. Salvador Randazzo's behavior in this case is what led to him getting suspended by the state bar. So yeah. So anyway, back to the standard of review. The standard of review, it says an appellate court reviews a trial court's decision on the grant or denial of a preliminary injunction under the abuse of discretion standard of review. Then it cites some legal bullshit, and then it says, discussing the standard of review. This court has explained, a trial court has broad discretion in the granting or denial of a preliminary injunction and will not be disturbed on review absent clear abuse of that discretion. And then it cites some legal bullshit here, and it says that broad standard is of course based upon the conclusion that the trial court committed no error of law and was not manifestly erroneous or clearly wrong in making a factual finding that was necessary to the proper exercise of its discretion. And some other legal bullshit here. And then it says discussion for preliminary injunction regarding injunctive relief. Honestly, I don't know if I'm gonna read. I guess I will. Okay, I don't want to read all of this, but I guess I am going to. For discussion, for preliminary injunction regarding injunctive relief, Louisiana Civil Code Procedure, Article 3601 provides, in pertinent part, A. An injunction shall be issued in cases where irreparable injury, loss, or damage may otherwise result to the applicant, or in other cases specifically provided by law. Item C. During the pendency of an action for an injunction, the court may issue a temporary restraining order, a preliminary injunction, or both, except in cases where prohibited, in accordance with the provisions of this chapter. And then it says, injunctive relief is an equitable remedy, which is ordinarily only available when a party has no adequate legal remedy. And it cites some shit here, and it says, it constitutes a harsh, drastic remedy that should only issue where the petitioner is threatened with irreparable harm and has no adequate remedy at law. And then it cites some legal bullshit here, and it says, a preliminary injunction is an interlocutory procedural device designed to preserve the existing status quo between the parties pending trial on the main demand. And some other legal bullshit is cited, and then it says preliminary injunctions can be prohibitory or mandatory. And some other legal bullshit here. It says a mandatory injunction orders the doing of something, while a prohibitory injunction seeks to restrain conduct. And some other legal bullshit is cited here. And then it says, the party moving for a preliminary injunction bears the burden of proof and must show that 1. The mover will suffer irreparable injury, loss, or damage if the motion is not granted, and 2. The mover is entitled to the relief sought, and 3. The mover will likely prevail on the merits of the case. And some other legal bullshit cited here, and it says, the procedural requirements to satisfy the standard of proof required to meet the elements for a preliminary injunction differ, contingent upon whether the preliminary injunction sought is a prohibitory injunction or a mandatory injunction. And more legal bullshit is cited. It says if the mover seeks a prohibitory preliminary injunction, the mover must make a prima facie showing. Yet, if the mover seeks a mandatory preliminary injunction, the mover must demonstrate the elements by a preponderance of the evidence at an evidentiary hearing. And some more legal bullshit cited here. Regarding the first element, irreparable injury is a loss sustained by an injured party which cannot be adequately compensated in money damages or for which such damages cannot be measured by a pecuniary standard. And more legal bullshit is cited. However, if the mover seeks a prohibitory preliminary injunction as opposed to a mandatory one, then the mover may be entitled to injunctive relief without the requisite showing of irreparable injury. I do not understand why this is, like how this is legally, but whatever. Anyway, it says, to avail oneself of this exception, the mover must make a prima facie showing that the conduct sought to be restrained is unconstitutional or unlawful. That is, it constitutes a direct violation of a prohibitory law and or a violation of a constitutional right. And more legal bullshit is cited here. Thereafter, the trial court will grant their prohibitory preliminary injunction if the trial court determines the following requirements. A. The conduct violates a prohibitory law, ordinance, or statute, or the Constitution. B. The injunction seeks to restrain conduct, not order it. That is prohibitory as opposed to mandatory. And C. The mover has met the burden of making a prima facie showing that he is entitled to the relief sought. And some other shit is cited. And it says, further, the jurisprudence makes clear that only direct violations of a prohibitory law may be enjoined without a showing of irreparable harm. And some more legal bullshit cited. Courts have found this prerequisite satisfied only when there has been a clear violation of express law, not cases of arguable violations. And more legal bullshit is cited. So basically, sum that all up, it looks like they're saying to me, even if you can argue semantics about a law violation, then that doesn't apply. But if it's not about arguing semantics, it's clear as fucking day, then it applies, if I'm not mistaken, where something can go forward without evidence. You know what I'm saying? Because I guess the fact that something happened is evidence enough. You need no more evidence of it, if that makes sense, right? I don't know. But anyway, so then here we have our analysis. It says, as the procedural requirements to satisfy the standard of proof required to meet the elements for a preliminary injunction differ depending upon whether the preliminary injunction sought is a prohibitory or mandatory one. we commence our analysis by determining whether the injunctive relief sought by appellants was prohibitory or mandatory. Some legal bullshit is cited here, and it says appellant sought to enjoin future shareholder meetings for the alleged failure of the meeting to comply with Louisiana Business Corporation law, and they sought to enjoin approval and enforcement of the proposed settlement agreement. Because they sought to restrain conduct rather than order conduct, this was a request for a prohibitory injunction, not a mandatory one. Some legal shit is cited here. Having determined that this was a request for a prohibitory preliminary injunction, we next determine whether appellants made a prima facie showing that 1. They would suffer irreparable injury, loss, or damage if the motion was not granted. 2. They were entitled to the relief sought. And 3. They will likely prevail on the merits of the case, meaning that they'd likely win. Beginning with the irreparable injury element, in their motion for injunctive relief and in briefing to this court, appellants argue that the preliminary injunction should have been granted to prohibit future shareholder meetings and to enjoin approval or execution of the proposed settlement agreement. They argue that the proposed settlement agreement did not adequately compensate them or the corporation for the damages arising out of the corporation's lawsuit against the parish and Hard Rock Construction. Further, the underlying lawsuit also sought an award of money damages. Thus, all known relief arising from appellants' efforts to enjoin the execution of the proposed settlement agreement is susceptible to quantification in money damages. Appellants have not identified an irreparable injury, that is, a non-monetary or non-economic harm, which they will suffer in the absence of injunctive relief. Some other legal shit is cited here. Rather, appellants combined assignments of error contend that appellants are exempt from the irreparable harm requirement because the conduct they sought to enjoin violated one or more prohibitory laws. In assignments of error numbers 1 through 5, appellants assert the violation of certain laws or formalities regarding the negotiation and approval of the proposed settlement agreement. Specifically, in assignment of error number 1, appellants contend that the meeting was improper because it contained no election of a meeting chairperson, and Ms. Beck acted as corporate secretary. They assert that these actions violated some legal procedural bullshit, respectively. Appellants assert in the second assignment. I don't know what the fuck I just thought I heard. I'm hearing shit right now. Apologies. And now I feel like I look and sound crazy. Anyway, I'm like, excuse me, I'm just hearing things. Whatever. So appellants assert in the second assignment of error that it was illegal for Ms. Beck to obtain proxies from the children of the descendant, Camille Randazzo Ruiz. I don't know if I'm saying that right, man. I say it every time. Without a copy of descendant's will, formal letters, testamentary. I think I'm confusing descendant with dissident. I don't know. Whatever. Yeah, whatever. The dead person, man. Apologies, that was rude. Okay, so life is hard. Okay, so they didn't have a copy of Camille's will, formal letters, testamentary, or a judgment of possession, placing the children into possession of the estate. Similarly, in the third assignment of error, appellants argue that it was illegal for Ms. Beck to obtain proxies granted by the surviving spouse of the of the dead dude, Manuel J. Randazzo Sr., to her attorney without a copy of the dead guy's will, formal letters, testamentary, or a judgment of possession. placing the surviving spouse into possession of the succession. Possession of the succession would be a really good title for a will, estate, probate book, in my opinion. Okay, so footnotes. It says Louisiana revised statute something bullshit, I'm not doing that, states that at each meeting of shareholders, a chair shall preside. The chair shall be appointed as provided in the bylaws, or in the absence of such provision, by the board. Appellants contend Ms. Beck was not directly appointed by the board. Instead, they argued that she improperly installed herself as the chair based on the fact that she held the proxy of the corporation's then president, Randazzo Torres. But, okay, even if that were true and that were an issue to be resolved within the company for future meetings, would that have changed the outcome of the bullshit reasoning you're using to file this lawsuit anyway? You know what I mean? I don't think it would. But that's just me. Like if the family wanted to do something and their interests all had certain percentages, it doesn't really fucking matter does it matter who's leading the meeting in terms of which way they're going to vote? Does that matter that much? Maybe it could, depending on the personal politics and relationships, right? But like if a bunch of them sent proxies because they didn't want to see each other and those proxies were already told which way to vote, then would that change based on which proxy is leading the other proxies? You know what I mean? It sounds more like he's just like really upset that he's the one that showed up and nobody else wanted to meet with him. Or maybe I'm wrong. I don't know. Okay, and so the next footnote says that another Louisiana revised statute, I'm not fucking trying this, assigns to the secretary the authority and responsibility for preparing the minutes of the directors and shareholders meetings. Appellants suggest that inasmuch as Ms. Beck was not the duly appointed secretary of the corporation, all acts she performed in that capacity were invalid. So I guess that's where they're trying to use that argument to say, well, since she was in charge, nothing that was decided in this meeting is legal, therefore, you know what I mean? Trying to just invalidate anything he can, but I don't know. You know what I mean? Okay, so, picking up where we left off a minute ago, it said appellants contend that the actions outlined in assignments of error numbers 2 and 3 constitute violations of some other Louisiana revised statute bullshit. In the fourth assignment of error, appellants allege that it was illegal for Ms. Beck to accept documents and make them part of the meeting after the adjournment of the meeting. They cite this as a violation of some other bullshit. Further, in the fifth assignment of error, appellants contend that it was illegal for the qualified director of the corporation, Randazzo Torres, to permit her son, Mr. Torres, to act as the attorney in negotiating the proposed settlement agreement without having disclosed any conflicts of interest. Without having disclosed any conflicts of interest? Are you fucking kidding me? That's your fucking cousin, bitch. Did it need to disclose that's your fucking cousin, motherfucker? Like, are you fucking kidding me? In any other situation, like these are people who didn't fucking know each other and were not related to each other, that would make sense. Or even if they knew each other, if they were not related to each other, and it wasn't a family business to a point, I believe that would make sense, you know, because it could, in those situations, it would not necessarily be legally clear, and it should be legally confirmed, these things. But as I've already discussed, when this is a family business and you all have this one common ancestor, and so therefore based on your relation to this ancestor, whether he's your father or your grandfather, that comes into play. And then based on whether or not you married in, all of that is what factors into the percentage of your ownership in the company, right? Theoretically. If I'm not mistaken. Besides, I'm not sure how the original Lina Randazzo Torres ended up being the majority shareholder as a president, but that's not my story to know. But, besides these political things with the percentages, in terms of who is part of that inheritance, what y'all all have in common is descending from Mr. Samuel Randazzo, or not Samuel, he went by the name Sam, which is why I keep getting fucking confused by that. The original Salvador Randazzo that went by the name Sam. He really should have gone by Sal. What the fuck? Anyway, so that guy is what they all have in common, right? So, in my opinion, it's like, this is your cousin. These are your family members. Already know what the conflict of interest that exists is. To be like, they didn't disclose to me that they were my family, and I forgot that they were my family, so therefore I didn't know that that was a conflict of interest, is like fucking bullshit in my opinion. It's a waste of fucking court resources, in my opinion. I'm sorry that I'm spiraling on that, and that took me forever to get to that damn point, but you know what? I'm sorry, or you're welcome. So, anyway, before we continue though, I'm just going to read these footnotes. It says, Louisiana revised statute some bullshit provides in part that an appointment of a proxy is effective when a signed appointment form or an electronic transmission of the appointment is received by the inspector of election, the secretary, or other officer or agent of the corporation authorized to tabulate the votes. Appellants represent that Lorene A. Randazzo was the duly authorized secretary of the corporation, and because she never accepted for tabulation the proxies held by Miss Beck or the representatives of the claimed heirs of Camille Ruiz or Manuel J. Randazzo Sr., the proxy votes were ineffective. So, yeah, he's basically, like I was saying, Mr. Salvador is just trying to argue, because they use proxies, basically, that this whole meeting is invalid, and like he's just basically trying to invalidate the legality of the agreement that the corporation came to and agreed to come to with St. Bernard Parish, in my opinion, because he just didn't want to do an agreement with St. Bernard Parish, But why would he be willing to fuck up the rest of your relationship with your family for that? You know what I mean? There are certain things that I guess I'm just not processing. I think it has to do partly with greed. Maybe it does have to do with aspects of greed. Before I was saying I didn't have any evidence previously for me to believe that it had to do with greed, so therefore at that point I believed it had to do with grief. But where he does seem to be, in my opinion, kind of resentful about basically the concept of, other people have the ability to outrule him, that does seem to come from a place of wanting more of a stronger power dynamic in the family, which could be perceived as greed, in my opinion, potentially. Anyway, okay, so the next footnote says that Louisiana revised statute some bullshit provides if the name signed on a vote, consent, waiver, or proxy appointment corresponds to the name of the shareholder, the corporation, if acting in good faith, is entitled to accept the vote, consent waiver, or proxy appointment, and give it effect as the act of the shareholder. Appellants contend that no documentation was presented during the pendency of the meeting to verify that Cheryl Randazzo was a named shareholder, and that it was thus illegal for Miss Beck to supplement the record post-meeting with the judgment of possession to establish Cheryl Randazzo as a named shareholder. Ooh, so that part could be different. I could kind of understand. So previously in all of my arguments, I had the logic and understanding that these were named people involved in these business proceedings from the past, like from a long history of that. But from this right here, if it is true that, certain family members, like, am I not mistaken? Is Miss Cheryl Randazzo Mr. Manuel Randazzo's wife? Is that who she is, if I'm not mistaken? Look, to be honest, I forgot who she was. But if that is who she is, then I think that, the fact that I could kind of see where in some families, just because you marry in, yes, they believe that you are entitled to a certain aspects because of your work in the family, but on another level, you wouldn't necessarily be entitled to being a part of that family business just because you married into it, you know? What you would inherit from the family business or from your marriage into someone who is part of the family business wouldn't make you part of the family business. It would just make you a beneficiary of some of their assets. I don't think I'm using the right words, but read my mind, you know what the fuck I mean, right? But in this situation, if I could kind of see where there would be some feelings where it's like, this is a family business from these specific ancestors, so if you marry in, if you didn't actually descend from this family business, then, you know, unless it's unless it's I feel like, you know, when people die and you're trying to restructure who is owning what, that is not the time to name new people as shareholders, you know what I mean? I feel like you need to already have agreement in place as to your current structure before you name other family members as part of the business, but maybe I'm wrong. Alright, anyway, I don't remember if I read all of that or not, but I'm gonna just keep going. There's one more footnote here, and it said that Louisiana revised statute provided the following: that a qualified director is a director who meets the following criteria. But then it gets confusing because it's like, where I think it's the footnotes, and then where the next page begins. Okay, so I think page 18 here is a continuation of the footnote, and I think page 19 is where the rest of this document begins. So apologies, the way that they put this together confuses me. Because right here, this sentence from, so below, we were just reading some footnotes. Before we were continuing the footnotes, it said based upon the, so to finish that sentence, that I believe continues on page 19 here, based upon the alleged violations, because that would fit together. And then where it lists something, I believe for the criteria, I believe this is the criteria. So I'm going to keep reading here. Okay, so the Louisiana revised statute provides the following. A qualified director is a director who meets the following criteria. 1. At the time action is to be taken under some revised statute bullshit, does not have either of the following conflicting interests. A material interest in the outcome of the proceeding. B, a material relationship with a person who has such an interest. And then number 2, at the time action is to be taken under some other revised statutes, does not have a material relationship with a director described in either subparagraph A or B of this paragraph, and is not either of the following. A party to the proceeding. B, a director as to whom a transaction is a director's conflicting interest transaction, or who sought a disclaimer of the corporation's interest in a business opportunity under revised statute some other bullshit, which transaction or disclaimer is challenged in the proceeding. Number 3, at the time action is to be taken under some other revised bullshit, a director who is neither of the following. A, a director as to whom the transaction is a director's conflicting interest transaction. B, a director who has a material relationship with another director as to whom the transaction is a director's conflicting interest transaction. And number 4, at the time action is to be taken under some other revised statutes, would be a qualified director under paragraph A3 of this section if the business opportunity were a director's conflicting interest transaction. Number 5, at the time action is to be taken under some other revised statute bullshit, a director who is neither of the following. A director to whom the limitation or elimination of the duty of an officer to offer potential business opportunities to the corporation would apply. A director, B, a director who is a related person to another officer to whom the limitation or elimination would apply. Then it says, for purposes of this section, oh, it looks like the footnote continues down here at the bottom. These are the longest fucking footnotes ever. All right, I'm going to finish out this footnote section. And then it says, for purposes of this section and another revised statute, number 1, material interest means an actual or potential benefit or detriment other than one that would devolve on the corporations or the shareholders generally, that would reasonably be expected to impair the objectivity of the director's judgment when participating in the action to be taken. Number 2, material relationship means a familial, financial, professional, employment, or other relationship that would reasonably be expected to impair the objectivity of the director's judgment when participating in the action to be taken. And C, the presence of one or more of the following circumstances shall not automatically prevent a director from being a qualified director. Number 1, nomination or election of the director to the current board by any director who is not a qualified director with respect to the matter, or by any person that has a material relationship with that director acting alone or participating with others. Number 2, service as a director of another corporation of which a director who is not a qualified director with respect to the matter, or any individual who has a material relationship with that director is or was also a director. Number 3, with respect to action to be taken under some revised statute bullshit, status as a named defendant, as a director against whom action is demanded, or as a director who approved the conduct being challenged. That was a lot of bullshit just to fucking basically say that because, I think they're basically trying to argue that because the proxy chosen worked for Sydney Torres, that was part of why she was also invalid too. And basically all of those words put together, I think, is another reason that Mr. Salvador Randazzo was trying to use to invalidate Miss Beck as a proxy. You know what I'm saying? If I'm not mistaken. But yeah, I could be wrong about that. But anyway, so continuing with the actual legal filing that's not a fucking footnote, it says, based upon the alleged violations and assignments of error, numbers 1 through 5, appellants assert an assignment of error, number 6, that the trial court committed manifest error by denying their request for injunctive relief because the action sought to be enjoined is a violation of prohibitory law. Upon review, we find that appellee's opposition to the enumerated violations establish that if the violations were in fact violations of prohibitory laws, at minimum, the violations were arguable violations. Some other legal bullshit is cited. Arguable violations of prohibitory laws are not sufficient to remove an applicant from the necessity of proving irreparable harm to obtain injunctive relief. Instead, our jurisprudence requires that the conduct enjoined be a direct violation of prohibitory law. And they cite some other shit. Then it says, regardless, this court need not substantively review whether the statutes or succession formalities cited by appellants here and above are prohibitory laws, because a petitioner is entitled to injunctive relief without the showing of irreparable harm when the conduct sought to be enjoined is a direct violation of a prohibitory law. And they cite some other shit here. Appellants do not request a prohibitory injunction to enjoin appellees from violating the cited statutes, or a mandatory injunction to compel compliance with succession laws. Instead, they seek to enjoin future shareholder meetings that could remedy the alleged violations, and they oppose recognition of the judgments which purportedly legally designate Cheryl Randazzo and the Ruiz children as rightful heirs to Manuel J. Randazzo Sr., and Camille Ruiz, respectively. I mean, honestly, though, I think that is kind of fucked up when, like, you know for sure that's your damn aunt and your cousins, and you're trying to sit here and argue that they shouldn't be as, that they shouldn't have rights, you know? Like, really, the fuck is wrong with you, man? Like, okay, that's rude of me, but, you know, it comes off as quite, heartless, in my opinion. Like, she just lost her fucking husband. Right? Am I not mistaken? Like, damn. Anyway, accordingly, this court needs only substantively review whether the conduct appellants seek to enjoin is reprobated by law. Here, appellants identify the conduct they seek to enjoin as 1. Restraining and enjoining said parties, their agents, and assigns from setting any more meetings of shareholders or directors during the pendency of these proceedings, and 2. Restraining and enjoining some, what, I'm only saying some, I think it says same, restraining and enjoining same from taking any action concerning the Highland Double Lot, including but not limited to any meetings or agreements with the parish of St. Bernard or any of its representatives, and Hard Rock Construction, LLC, concerning the Highland Double Lot. And another bullshit legal thing cited here, it says this court determined that the irreparable harm exception did not apply to an employee who sought to prevent the Sewerage and Water Board, hereinafter S&WB, from prohibiting the employee from using a Sewage and Water Board vehicle to commute. The employee alleged that his rights to equal protection under the Louisiana and United States Constitutions had been violated when the Sewage and Water Board took away his assigned vehicle. The court concluded that the Sewage and Water Board's prohibition did not violate any express law and appeared to be a routine business practice. Yeah, that makes no fucking sense. What the fuck? Anyway. And then it says, likewise, in the case sub judice, don't know what the fuck that means, appellant's desire to enjoin, oh, does that mean in the case under this judgment or something like that? I don't know. Appellant's desire to enjoin shareholder meetings merely to prohibit a vote on the proposed settlement agreement of which they disapprove. This conduct, namely prohibiting appellees from having shareholder meetings and or having meetings or entering agreements with the parish and Hard Rock Construction regarding the property, does not violate prohibitory laws. On its face, resolution of litigation through negotiating or entering a settlement agreement is not conduct reprobated by law. Appellants do not contend or show that the proposed settlement agreement was for a purpose prohibited by law. I love when I stutter. No, I don't actually, but you know, language disfluency, language deprivation is a thing. The captioner keeps getting disfluency wrong. I think it's spelled, I've seen it spelled two ways, and I honestly don't know which way is right, but I've seen it spelled D-Y-S-F-L-U-A N-C-Y. Am I saying that right? I don't know. And I've also seen it as D-I-S-F-L-U-E-N-C-Y. So I've seen it both. With an I or a Y. But anyway, that's what I'm talking about. If you Google those symptoms and then watch me talk, you're like, oh, light bulb. But language disfluency is very common in deaf community. Yeah. So maybe I should do a live stream on that. Anyway, where was I? It says, likewise, conducting a shareholder meeting to vote on a proposed settlement agreement is not illegal. Appellants do not meet the first requirement to be relieved of the irreparable harm factor. That is, that the requested injunction will enjoin conduct in clear violation of a prohibitory law. Thus, we conclude that the trial courts did not abuse its discretion in denying appellants' motion for injunctive relief because appellants have not demonstrated that they are entitled to such relief. Further, having reached that conclusion, we pretermit I don't know, re-pretermit. I just honestly have never heard this word. Re-pretermit, what the fuck is that? Omit or mention. Omit to do or mention. Huh. Abandon. Okay. Discussion of the remaining requirements for obtaining injunctive relief without proving irreparable harm. Yeah, because it doesn't fucking matter. Because all three requirements must be met, and appellants fail to prove one of the requirements. We need not consider the other two requirements. It says decree. For the foregoing reasons, the trial courts May 10, 2021, which denied appellant's motion for injunctive relief, is affirmed. Okay, and so taking it back up here, maybe because I zoomed in so much. No. Apologies, I had zoomed in too much. It's like not letting me scroll. Okay. So, the appellant was Mr. Salvador, and the trial court denied his motion, and they granted the motion to dissolve the temporary restraining order that was filed. So basically, at the beginning, I think I did not understand, and I still kind of don't, but at the beginning, I think I was even more confused. At the beginning, I don't think I understood that if you look here where it says, okay, so the trial court, they denied the motion for injunctive relief and granted the motion to dissolve the temporary restraining order. So the motion for injunctive relief was, Salvador Randazzo was basically trying to say, in my opinion, that, you know, a relief is basically, if I'm not mistaken, okay, hold on. Because actually now I think I'm getting relief and remedies confused, so let me be clear here. So, it's a court order to make the company do something or stop doing something, right? Okay, so my understanding is Salvador was trying to make it so that the corporation could not go forward with the agreement with St. Bernard Parish, and that motion was denied. At the same time, if I understand correctly, at the beginning of this situation, I had thought that the restraining order was filed to prevent the other side from accessing the business funds and things of that nature. But now I'm understanding it was filed, reprocessing it, and I'm being more clear on these words here, you know, it was filed by the appellees, you know, by the Torres side, by the descendants of, if I understand correctly, of Manuel Randazzo. Actually, no, the Lina Torres is not the descendants of Manuel Randazzo. Lina Torres Randazzo is Lina Randazzo Torres, or whatever her name is. I apologize. Lina Randazzo Torres is Salvador Randazzo's aunt, if I'm not mistaken. And then other people related to Manuel Randazzo were named in this situation later on, which is why I'm getting that confused. So anyway, apologies. We're here now. Clusterfuck, right? But yeah, so basically it looks like the court situation, they sided completely with the Randazzo side, the family related to the Torres side, you know, as well as the descendants of Manuel. As far as the descendants of Lawrence, for Salvador, that side, it looks like the other side had put a restraining order filed on him, if I'm not mistaken, but that was dissolved. Or actually, I'm not entirely sure. I have it processed. I'm not entirely sure understanding this restraining order aspect, but I think that could have to do potentially with being able to make decisions on behalf of the business and speaking for the business, something of that nature. Because Salvador was trying to stop the business from going through with a deal. And so they probably filed that to prevent Salvador from being able to stop them from the deal they wanted to do, if I'm not mistaken. Basically. But yeah, so apologies. Me trying to process that is a shit show. So, just summing up today though, gonna try and give y'all a recap because it was a lot. So I spent the first portion, I don't really know how long I spent, probably a third of this live stream, on my hair. So we took down, I showed you guys the foam roller set I did yesterday, and the satin lined flexi rod set I did overnight. We took that down today. So we spent the first part of this live stream just talking about styling my hair, and then most of this live stream was more focused on the Randazzo family. We reviewed a little bit of yesterday's live stream. We talked a little bit about the family tree, just in terms of having some understanding for who were the people in these legal filings that we are discussing today. We did use Mr. Manuel Randazzo Sr.'s obituary, so may he rest in peace. That obituary, I just wanted to use it because it did kind of explain and give some clarity as to who some of the people involved in this paperwork was, you know. So I mean, no disrespect by that, but yeah, we did look at that. And so we also looked at a blurb from the Louisiana Ethics Organization, Legal Ethics Organization, about the language that Mr. Salvador Randazzo used in the legal filings and in other conversations related to the procedures here to the judge. And then we looked at the documents that I could find about this case. The first document was kind of a summary of the case, but more about some of the things that Mr. Randazzo, that Salvador Randazzo was saying to and about Judge Roy specifically, I think. And then we also looked at, spent the majority of this live stream looking at the 2022 case that I could find on why Mr. Salvador Randazzo got suspended, you know. The reasons he got suspended took place from two situations. The first being the 2021 situation as it relates to his family affairs, and the second being the appeal of that case. He tried to appeal it and it didn't work out for him, if I'm not mistaken. So basically, you know, he was trying to prevent his family from doing business deals he didn't want done with St. Bernard Parish. His family won the legal proceedings in order to continue doing the business they wanted to do, if I'm not mistaken, and then he tried to appeal that. And he lost that appeal, and in all of these legal proceedings and paperwork, he also kind of went off on the judge as well as the judge's staff. And then he ended up getting suspended from the state bar for like 3 months. I mean, not 3 months, 3 years. And I think half of that is deferred. If I'm not mistaken, I think that means it's kind of like probationary, but if you do anything, you're fucked, you're done. You know what I mean? If I'm not mistaken. Like you have to do the rest of the time. I don't know for sure, but I think like half of it, he goes back and like half of it he's not allowed to practice at all, and then the other half they put him back into like ethics training or some shit like that, if I'm not mistaken. But yeah, so basically, you know, he got called out, and they literally said in the legal paperwork that they were gonna humiliate him, if I'm not mistaken, if I interpret that correctly at one point, and things of that nature. So I was like, damn. Yeah, and so we ended up covering that, and we're here now. So yeah, I kind of, you know, I started this looking into this because I was entertained, and then I kept looking into it because I always you know, am really fascinated in cases where there are patterns of self-destruction, because it just makes me question, like, why do people do the things they do? You know what I mean? I don't know. So I do feel for all of the Randazzo family. They've lost a lot of loved ones lately. And so I hope they're all on a healing journey with their grief. I hope they all do come back together again and are able to overcome their differences and make amends and do better going forward, because, you know, I don't believe any family business is ever built with the intention that people would be fighting over who gets the next king cake slice, when at the end of the day, whoever finds the baby in the king cake is the one that gets the king cake slice. So do it for the babies, man. I'm just kidding. I'm being fucking weird. But like, on my dad's community, you know, my dad, he's indigenous. Everything about his side of the family, like, they think about what is it going to be for the next 7 generations. They plan for 7 generations forward. You know, we're always planning for our children, for our future. And I think, you know, like, when the family business was built, that was the intent, is what I believe. I do believe that the main core intent of the family business is to support the family. And I hope that family is able to remember that and stick to that and heal, discuss their differences, and come together. And, you know, I think it possibly, in the moment, I can understand how things are perceived as greed when you look at it superficially, but also when you look into the social issues and the history and you try to understand things, I think it comes from grief. I think it comes from mental health and community and feeling disconnected from the loss of members of the community. And I think what they need is to reconnect again. You know what I mean? But yeah. So yeah, that's just me spiraling and cycling and everything. So thank you for processing life with me today. Thank you for processing business and law and ethics and morality. I appreciate you guys. I hope everything works out for everybody. Yeah, I cannot wait for king cake season. Yeah, anyway. Alright, well, I appreciate you. And have a good one. Where the fuck is my out button? Alright, bye. Thanks for watching. Join the loyalty program at noladeafchild.com/loyalty and check in during live streams to get points for rewards.